Thank you very much, Joanne. And I have to say, I really have been delighted to receive the invitation to deliver this Castan Centre Annual Lecture on the topic of business and human rights. I knew Ron Castan a little many years ago when he was practicing and taking on so many pro bono human rights cases. And I remember one particular case of a man who was about to be deported, and Ron did absolutely everything he could, ultimately bringing the matter to the High Court to argue that this man should not be deported and should be given refugee status. I was very impressed at that time with Ron's legal and advocacy skills and his very genuine commitment to human rights, little imagining that one day my own professional life would be engaged in this particular aspect of public international law, for asylum seekers do take up a great deal of my time as president of the Human Rights Commission. Well, corporate social responsibility is one of the most important challenges for business in the 21st century. There's an increased recognition at the national and international levels that respecting human rights is good for business. The Australian Human Rights Commission has also identified developing a positive relationship between human rights and business is one of its most important strategic priorities over the next couple of years. I too would like to thank the organisers of the event, the Castan Centre itself and King & Wood Mallesons. The Castan Centre has been doing some excellent work in the area. You'll know that in 2008 in partnership with the Office of the High Commissioner for Human Rights, released the Human Rights Translated, a business reference guide, which is a very valuable resource and demonstrates why human rights can and should be protected by business, both as an obligation and as a sustainable financial strategy. And of course, I'm very happy to commend my firm, King & Wood Mallesons. I was with them for many years, as Joanna has said. They are the only large commercial law firm in Australia with a dedicated human rights practice, and I know they dedicate many of their resources to pro bono advocacy. Can I also acknowledge that we gather on the land of the Wiradjuri people of the Kulin Nation, and I pay my very genuine respects to their elders, past and present. Well, this afternoon, what I'd like to do is give you some sort of a brief overview of the international framework for the responsibility of the international community for human rights implementation. But I then thought I would look at the work of the Human Rights Commission itself to attempt to encourage government and business to implement the three pillars under the guiding principles on business and human rights known as the Ruggie Guidelines on respect, protect and remedy. When I was thinking about what I might talk to you in particular today in this rather broad topic, I thought that as a former academic, I probably would have regaled you with details of treaties and case studies and evolving jurisprudence and said to you there are international legal obligations on businesses to do the following. Well, it's very interesting that although I've only been in this job for 16 months, my view of really 45 years in public international law has been somewhat moderated by the reality of day-to-day trying to achieve an implementation in Australian domestic law of the international legal principles that I've been so happy to talk about, both in commercial practice and as an academic. So I did think that I would concentrate today on the more practical aspects of what it is that the Human Rights Commission does. But perhaps just to mention, the Castan Lecture is of course very timely because next week the Australian government will assume the G20 chair, which provides Australia with an opportunity to put human rights on the economic agenda for that group. The G20 members account for 85% of the world economy, 80% of global trade and 2/3 of the world's population. So this position for Australia as chair does provide a significant opportunity to link economic growth with fundamental rights and freedoms. And let me give you just a very, perhaps even banal example of the way in which community demands for greater social responsibility for business is arising. Just a few days ago, close to home in Adelaide, the Sunday Mail reported that a local clothing shop was selling t-shirts with the word retard on the front. The public response in Adelaide has been one of real anger and outrage that these products demean those with intellectual disabilities just at a time when the community is starting to understand mental illness and to support efforts to respect and support those who are afflicted. The director of the company is reported to have withdrawn the product immediately, but demanded the suppliers that take back the stock Well, the suppliers apparently refuse to do so. But the point of mentioning this instance is that the impact can be very significant for an otherwise successful business, and it seems commendable at least that the shop itself has understood that a socially responsible response will ultimately be in its best interests. And there are all sorts of other examples that one can talk about in terms of a growing community recognition of the role and the important leadership role of business in implementing human rights in practical ways. Qantas, for example, works with the supply nation to ensure that the supply of many of the products it delivers are provided through an Indigenous body that enables Indigenous groups to supply particular services and goods. KPMG works with the particular Indigenous groups in partnerships. Westpac provides leadership in creating sustainable housing that's designed for rural community living. Lend-Lease works with community housing in certain areas. There are numerous examples of Australian businesses coming to grapple with the ways in which they can adopt socially responsible policies. The support for integrating human rights in economic strategies is very clear when you look at the buy-in to the United Nations Global Compact, which broadly creates a voluntary commitment to human rights in developing strategic policy for the business community. That compact now has 12,000 participants across 145 countries, and there are almost 8,000 Australian businesses, along with universities, NGOs, government bodies and other agencies that are now part of that global compact. There are around 120 Australian signatories, and the network is growing. The Australian Human Rights Commission, of course, takes the position that when businesses breach human rights, particularly in the context of the 4 primary pieces of legislation for which we're responsible, dealing with race, sex, disability and age, those businesses will obviously be in violation of Australian law, with all the attendant consequences of conciliation procedures and possible forms of compensation, and ultimately, though in very few cases, federal court litigation. However, a vital tool we have come to believe to achieve human rights outcomes, which are obviously our first priority, is to achieve systemic change on a voluntary basis. And one way to do this is to make the business case for human rights implementation. Global and Australian research indicates that there's a strong business case that gross domestic product will increase significantly in economies that achieve diversity in employment, equality of opportunity, and recognition of merit. The UN, the OECD, the World Bank, Asian Development Bank, Human Rights Council, each agrees that there's a direct connection between good business and fundamental human rights in building economic and social development and entrepreneurial productivity. If we take, for example, the area of age discrimination, the Commission appointed Deloitte's Access Economics to conduct primary research to measure the economic impact of employment participation rates for people over 55 years of age. The study found that in 2012, an increase of 5% in paid employment for Australians in that age group would have led to a 48 billion impact on the national economy in that year alone. The study also found that in 2011, 18% of the unemployed over 45 said that they believed that they were unemployed because of a prejudice against them. A 5% increase would, in human terms, mean an extra 750,000 people over 55 could be in paid work rather than depending on current government benefits. So that example alone demonstrates that were we to be more careful about discriminating, as we clearly seem to be against particular age groups, we would untap a very significant resource for benefit to the national economy and, of course, to the companies concerned. With regard to sex discrimination, Goldman Sachs have reported, both on their American-based research and Australian research, that in 2013, if the gaps between male and female employment and productivity were to be closed, it will boost Australia's GDP by 13%. The Grattan Institute has concluded that a 6% increase of women in the paid workforce will expand the Australian economy by about 25 billion a year. And the same argument applies in relation to disabilities and to race and Indigenous employment. And the evidence is now really compounding, both internationally and within Australia. Embracing human rights helps a company manage business risks such as litigation, damage to stakeholder relationships, reputation and brand image. Compliance with human rights creates new business opportunities, including strategic advantage in emerging markets. And one that my colleague, Susan Ryan, who I'm sure you will remember, the first woman to be appointed to a Labour cabinet, she's now the Age Discrimination Commissioner, is constantly telling me about businesses who've identified that the people with the money are actually in that top echelon. They should be developing products and selling to that market, not only, of course, employing them. And a very good example of a company that has embraced human rights, and I'm recently, I'm ashamed, I think, in mentioning particular companies, but this one, Rio Tinto, has a policy that works globally for them, as well as in Australia, and it has a significant impact on their activities and culture as a whole. They have a report or a policy why human rights matter, and they have in particular embraced a policy of free, prior and informed consent in their extractive minerals industries globally. They are the largest private employer of Australian Indigenous people, First Nations people, and they employ 7% of the total workforce in Australia, which is quite extraordinary. And they have been, in their website, identifying what they see as the challenges to their businesses if they fail to respect human rights. They say human rights, or getting human rights wrong, can pose real risks. They include operational delays, legal challenges, reputational harm, lost opportunities, investor concern, and employee dissatisfaction. For our business, they say, to succeed, we need to understand and manage human rights risks. We must act responsibly in respecting human rights in both developed and emerging economies in our core business. Now that's a very positive story, but I also have a rather, perhaps a curious one that I think I can say without giving too much away. But perhaps some of you will be aware, certainly those of you who maintain an interest in public international law, that we had a long-term problem in the Western Sahara. After Spanish colonialisation, the United Nations held a plebiscite, and that plebiscite essentially was for independence. But rather than independence occurring in Western Sahara, the Moroccans engaged in what was rather euphemistically termed a green march, and literally took over the north-western part of the country, leading to the civil war with the Polisario. Now, the upshot of all of this rather complicated background is that Western Sahara does not have recognised statehood in the international legal community, but it does have a lot of phosphate, and companies and extractive industries work there to a degree. And I was asked to give some legal advice before I took up this position, because I can't do that anymore, but to advise the company on how they were going to manage this. But because they were clearly making a profit, it's one of the most important phosphate industries in the world, very important as this has declined in Australia. But they were worried, because they were worried about their reputation, worried about social responsibility, and what the legal consequences might be as years go by on the ultimate rights of the peoples of Western Sahara to independence, consistently with the UN plebiscite. And we talked about various ideas, as lawyers will. What about setting up an escrow account for a percentage of the profits that could be held and ultimately distributed? What about making sure that there are proper services within the area in which the mine was operating, school, opportunities for women to work, opportunities for education and health services. Now these were all discussed around the table, but nobody seemed to really know what was going on there. And I said, well, has any of the directors of this very well-known international company has any of the directors ever been there? They ever looked at what the conditions are really like, talked to the people, seen what their concerns are and how they feel about a non-renewable resource being used in this way under a Morocco concession agreement? And the directors sort of looked at each other somewhat bemused and said, well, no, not one of them had ever been there, had ever had any connection with the actual working operations of the mine, although they said maybe they, obviously their managers did, but they'd never been as directors of the company. And I said, well, you could, for $10,000, one of you could get a business class airfare over there and go and have a look. You fly to Paris and you get a 2-hour flight down to Western Sahara. It wouldn't be difficult. But surely these are the ways in which you can be a little more connected with the extractive industries and at the same time, of course, protect your business reputation. But that was merely a war story, and it is, of course, one thing for a major transnational company to understand the link between economic outcomes and human rights. They are well-resourced, they employ skilled professionals in personnel to stay abreast of changes to human rights and discrimination law, and to implement those laws, as they almost invariably do, in their management policies. But it's quite another for human rights policies to be recognised and adopted by small to medium enterprises. It's in respect of the smaller, often family-run businesses that human rights are most likely to be at risk. And this point is all the more powerful when it's understood that small to medium businesses employ about 7 million Australians. And I have to be straightforward in saying to you that small to medium businesses are very quick to point to the Australian Human Rights Commission as being part of that regulatory environment which adds cost to their business without, in their view, any really significantly valuable outcome. It's a transactional cost, it's a red tape, and it feeds in, of course, to political concerns about what the role of the Human Rights Commission is and whether it really is providing a valuable service to the Australian community. And that is something that we have to be very alert to in developing our priority over the next year or so. The perception that we're really just in the way, we're really just imposing regulatory controls in a way that are not financially sustainable. And so I am very keen to turn that argument around and to understand the research which suggests that diverse communities in employment and ones that abide by fundamental principles of human rights law as they're implemented in Australia will ultimately be to their best interests. Well, the Australian Human Rights Commission is, I believe, in a unique position to observe the extent to which businesses are pivotal to achieving practical human rights in Australia. And this is because of the overwhelming number of inquiries and complaints that we receive that apply annually in the area of employment law. When we distill, and I won't go through all of what we do, but when we distill the work of the Commission, we, at least a third to 40% of our work is concerned with the complaints mechanism set up under our legislation. And that leads to, on average, 17 or 18,000 complaints a year, inquiries and complaints a year. Those complaints are something like 70% related to the employment context. Some to services and delivery of services and products within the community. But basically, if we distill and try to understand what the Commission actually does confidentially and away from the media spotlight, it is in the area of working with businesses to try to achieve better outcomes in relation to allegations and complaints about age, sex, disability, and the rights of Aboriginal and Torres Strait Islanders. And that's why the Commission is now prioritising this question in our education and advocacy work. The aim being to achieve systemic change, as I said a moment ago, predominantly on the basis of voluntary codes of conduct, rather than drawing these companies into a complaints process. Nobody really likes it, and it's far more healthy for us to work with these companies right at the beginning, or with small businesses, rather than bringing them into the Commission to conciliate matters that can be rather embarrassing and difficult. It's very often the case that, of course, that the senior managers who come into the Commission to deal with complaints against them will often say, we had no idea that a particular person was abusing someone on the grounds of race in the canteen, or that somebody had been mysteriously let go 2 weeks after they'd announced they were pregnant. or that somebody didn't get a promotion because they were 55, but the 25-year-old with far fewer qualifications got the job. The managers are often quite unaware that this is occurring, but once they become aware, they can go back to their businesses and start to achieve some sort of systemic change. So that's the path we would really prefer to go down. But let's return, perhaps, to the beginning, and that is with the development of modern human rights law, and see what's been happening in the international arena before I come back to the domestic sphere. And that, of course, is we'll begin, I think, is a good place to start, is 1948 Universal Declaration on Human Rights. And I love to start here because you'll all be aware that it was our brilliant, if rather testy and demanding Doc Evatt who was the powerhouse behind Australia's support for the Universal Declaration, and who was importantly at the time President of the United Nations General Assembly, when he managed to ensure that that declaration went through unanimously in 1948. Well, that declaration I do refer to a lot because that really was the fundamental rights that reflected evolving jurisprudence in the decades beforehand, indeed in some instances the centuries of common law that had developed around core individual rights, but are articulated in the instruments you're all familiar with, the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights. Well, this question of business and human rights arose for the first time in 2003 when the UN Subcommittee on the Subcommission on the Promotion and Protection of Human Rights sought to articulate a definitive list of rights for which companies were to have direct legal obligations under international human rights law. Well, that was a big idea in 2003. It led to the creation of UN norms on the responsibilities of transnational corporations. But there was, frankly, great scepticism, and it fell into desuetude. But 8 years later, a second initiative was attempted in 2005, when Professor John Ruggie was appointed to the UN Special Representative to the Secretary General on the issue of human rights in transnational corporations and other business enterprises. And that led to the Ruggie Guiding Principles of 2008 on business and human rights, and a policy that essentially had three pillars: to protect, to respect, and to remedy human rights abuses within a business framework. It was a landmark document. It was the first time that business was identified as having a clear role within the UN legal system. And it's now accepted, or the guidelines are accepted, as the authoritative global standard for addressing business. It wasn't revolutionary in legal terms. The first obligation is that states and governments have obligations to respect and protect and fulfill human rights and fundamental freedoms. The second pillar is that business enterprises are required to comply with their national laws, well, that's very obvious, and that they must act with due diligence to avoid infringing the rights of others and to address adverse impacts with which they're engaged. And thirdly, that where rights and obligations are recognised and respected, they must be matched with effective remedies. Now, the guiding principles don't create new legal obligations, but they do create a form of soft law that international lawyers love to talk about. I'm sure the practicing lawyers here are going to say, what on earth is soft law? It's either law or it isn't. I won't go into that debate, but I can say that from my now many years working in this area, the general public international law area, there's no doubt at all that these guiding voluntary codes do start to form building blocks that become normative in ways that ultimately are reflected in behaviour, and therefore ultimately produce outcomes in terms of protecting human rights. So although it's not the kind of hard law that as a young academic I really wanted to see, enforceable legal rights in the international system and in the domestic system, I have learned, and I certainly have learned in this job, the enormous power of grassroots commitment to voluntary targets, codes of conduct, even though there may not be technical ways of bringing them before the courts. That's really, for most intents and purposes, not the effective way to gain the cultural change and commitment to fundamental human rights. So I do see these as enormous steps forward. One area that I did think I would mention is the extraterritorial question of jurisdiction over transnational corporations. John Ruggie did find that states are not required under international human rights law to regulate the extraterritorial activities of businesses that are domiciled within their jurisdiction. Now, that was rather disappointing from my perspective, because as a young lawyer in the very early 80s, I was asked to work with the government on the responses to the United States Westinghouse antitrust legislation. I don't know whether any of you remember this, but Australia had, of course, its own restrictive trade practices legislation, as most developed countries do have, but we sold uranium monopolistically on the international market. There's nothing in international law that prevents you from acting in a monopolistic way. We were, Australian companies were prosecuted by the reach extraterritorially of United States antitrust legislation. And it meant that people like Rod Carnegie from Consig Rio Tinto couldn't set foot in the United States, because if they did, they would be immediately before an antitrust grand jury up for triple damages for breach of antitrust law. And there's no doubt whatsoever that Australia had collusively, along with 8 or 9 other countries, sold uranium in a collusive way. It was very disappointing in a sense that the extraterritorial reach of laws was not really a technique that John Ruggie saw as valuable. We saw some rays of light. The Alien Tort Claims legislation seemed to provide a vehicle, but the US Supreme Court in April this year in Kiobel and Royal Dutch Petroleum decided that the Alien Tort Claims Act did not have an extraterritorial reach. And a very important case, it concerned a claim by Nigerian plaintiffs that the members of the Royal Dutch Petroleum Company, British, Nigerian and Dutch companies, had abetted human rights violations leading to the execution, quite improperly, of, or tragically even, of the claimant. But nonetheless, these rays of light are starting to create an environment in which we will be looking for extraterritorial reach in relation to issues, and I mentioned only the BHP of Teddy case and the Fly River case, where you had the most extraordinary fictitious approaches to find a jurisdiction. Ultimately the matter was settled, but very, very difficult to manage. Now, what about the Human Rights Commission? Well, Eleanor Roosevelt made the point that human rights begin at home, and that is, of course, fundamental to the way in which the Human Rights Commission operates. We have a very, very curious position in Australia, as many of you will know. Australia, going back to the Doc Evatt days, has been a good international citizen. We've helped negotiate, very often drafted, and been heavily involved in the development of international human rights law, and we've ratified virtually every major treaty and relevant human rights protocols. But we have not introduced that legislation into domestic law, with some very particular exceptions: race, sex, and disability. But the International Covenant on Civil and Political Rights, the Economic, Social and Cultural Rights Covenants, the rights of the child, Refugee Convention, in tiny ways, in the Migration Act, possibly about to be lost. We do not have a Charter of Rights, and we have only one explicitly protected constitutional right for fundamental freedoms, the right of religion. So it's been very, very curious for the way in which the Commission has to work in protecting human rights, because we have to work through advocacy, through our complaints process, and through trying to set in place guidelines that can be of value. We have in particular been concerned then to work with business, and you'll be aware of my colleague Elizabeth Broderick in creating the group Male Champions of Change. I was very dubious when I came in as president. The very idea of having an all-male group as being the group that promoted sex discrimination law in Australia struck me as rather difficult for a 1960s brow-burning feminist to cope with. But I observed that what Elizabeth's achieved with this Male Champions of Change group has really been quite astounding and very effective in engaging senior business leaders in attempting to change the culture within their major organisations. And so I've become a bit of a fan of the concept. We've also got another one that's been very, very successful, and that is the Racism Stops With Me strategy that the federal government has given us the privilege to lead. And we've really engaged about 160 businesses and organisations in tackling racism. We've found it very effective. If, I'm sure you know this happens in Melbourne, it's been happening in Sydney, a lot of racial vilification and abuse on public transport. Somebody gets out an iPhone, it goes viral very quickly. Now that's not very pleasant, but it does mean that we've got objective evidence of these acts occurring now in a way that we never could before. You may know from media discussion we've had a 59% spike in race vilification claims in the Commission over the last year, and an astonishing increase in complaints. But what happens is that we will then, very often, they're usually very rarely legal proceedings, but we try to manage something if a complaint is brought to us, and frankly mostly complaints aren't brought to us. But when they are, then we'll try to deal with them. But what we try to do more proactively is to go to the transport company, a bus company for example, and say, well, this has happened. They will always say, of course, it's inconsistent with transport policy, but we're saying it's happened. Can you help us start to get greater awareness of what basic civility on public transport looks like? And they will almost always come to our offices, have a discussion, and go away armed with posters, with guidelines, and go back into their companies. And now in the buses and on the trains, we now see engagement by those business communities in saying this sort of behaviour is absolutely intolerable in a multicultural Australia, but intolerable in the way in which they run their businesses because they have an impact. Now, I think that I should perhaps just reiterate then that a little bit about what we do in the Commission. I've said that most of our complaints are in the employment field. To be more specific, in sex discrimination, 83% concern employment. Disability, it's about 33%. In age, it's about 60%. And in race, it's about 30%. We also, of course, have complaints under our general human rights mandate that bring us in on asylum seeker complaints, both offshore and onshore. And we manage to conciliate about 65% of the formal complaints and manage most of the others. So very few of these matters ever go to court. Perhaps 100 a year will go to the federal courts. They can't go to the court without coming to the Commission first. But I'm very pleased to say that the findings of ultimately the President in the Commission have never been overturned by the federal court. So we do spend a lot of time trying to balance these interests and to work effectively. I think that something that's not very well known is that we do a great deal of international work with China, with Indonesia and Vietnam, and we find that again, working below the radar, trying to work on very core issues like women, violence against women in rural areas, but doing so through state agencies and businesses can be a very effective way of achieving some outcomes that are consistent with Australia's objective. So I should conclude, and I think perhaps I'd like to make some very basic points. One is that the Commission does see a primary role for us being in education and training. I've been very surprised since coming to the Commission that people in the main do not understand much about who we are or where we are. We're about 140 people. We're in Pitt Street, right opposite the Mall. We're very accessible, except that people don't really understand. They think we're a group of 10 people operating out of Canberra. But significant taxpayers' resources go to support the Commission. But because at least a third of our work is confidential, it's not easy to get some of the work and the effects of that work out there. So education, training and greater public awareness is what I see a very important part of my job. We will continue to work with small to medium businesses, but we see a very important leadership role in the bigger companies. They've almost invariably got very good processes, guidelines, voluntary codes, but they could provide an important leadership role in working with the smaller businesses that can't afford the resources to develop these themselves, but where the work is often being done by major Australian companies. I think we have to be a little careful that some companies will tick boxes. One that's been in the news recently is the Reconciliation Action Plan in relation to Indigenous matters. A lot of companies have ticked that box, but perhaps aren't doing a great deal of work. Others are doing a great deal of very, very effective work, but I think it's something we need to be careful about. It's not just something we oversee as a formal statement, but is an absolutely genuine commitment to achieving human rights. I think that we, by acknowledging and understanding the business case, we can help to achieve real improvements in human rights law in Australia. in a voluntary way, and in a way that overcomes the difficulty that almost uniquely Australia does not have a legislative or constitutional base for much of the human rights work that we do. So it's an interesting model that we've developed in Australia, very strong parliamentary scrutiny, reasonably strong access to justice through organisations like the Australian Human Rights Commission, but very effective voluntary processes within the business community itself. Thank you very much indeed.
Gillian, we've got time for about actually 15 minutes worth of questions, so there's one.